Welcome to all. As a part of the course on insolvency and bankruptcy law in India, today we are going to discuss the concept of constitution of committee of the creditors. In this session, we have discussed the basic section. Then subsequently, we discussed that the related party cannot be a part of committee of the creditors. Now, in today's lesson, we are going to discuss who is considered to be related party. Because if you wanted to be a part of committee of the creditor, or if someone wants to be a part of committee of the creditor, first of all, the resolution professional shall decide who is considered to be related party. So in today's lesson, we are going to discuss who is considered to be related party. So we are having various circumstances are there. In various circumstances, various scenarios, who is considered to be related party, we are going to discuss. So section 5, subsection 24, clause A. So today mostly we are going to discuss section 524 only. So whether a director or partner of corporate debtor or a relative of such director or partner of corporate debtor, is he considered to be related party? There is a question mark. Okay. So in the case of GS Constro and Infra Private Limited versus Gajesh Lapchand Jain RP of ENG Global Estate Limited. So in this case, NCLAT held that the persons involved in day-to-day management or who accepts notices as suspended director. So any person, maybe they may not be called as board of directors. Okay, the name, because in company we are having so many people, C-level people will be there, board of directors will be there, who are involved in day-to-day activities. Okay, board of directors generally they are not expected to involve day-to-day activities, but they are the people who are going to guide the company. Okay. So the C-level people or any other person, whoever is involved in the day-to-day activities, or else whoever is accepting the notice. Okay, why? Because when interim resolution professional is appointed, he is going to send the notice to the existing board of directors, existing management there. So here, whoever is accepting the notice, okay, that is suspended director, they are considered to be related parties. Okay, so the suspended director or any person who is having grip over the day-to-day affairs of the company, he is considered to be related party in case of corporate debtor. Then in another case, Velli Parasma Shivam and Prism Johnson Limited. So in this case, NCLT Chennai bench held that the land owners who gave land for development in the real estate industry are related parties. Okay, suppose I am having one real estate project. Okay, so in that real estate project, suppose take the example, one corporate debtor, he came forward to construct the building. I am having the land. Now what I am doing is I am giving the land. Okay, the corporate debtor is constructing the building. So this is called as development agreement. So in this development agreement, the landowner, okay, is considered to be related party. Why? Because I am also related party. Okay, so I am also interested in that project. Okay, so I am also interested in the company. So that's why I am considered to be related party. Okay, whoever is the landowner who gave land for development in real estate industry, they are considered to be related party. Okay, then who else is considered to be related party? In one of the case, Asset Reconstruction Company India Limited versus R. Krishna Raju. In this case, NCLT Chennai bench held that joint development agreement in relation to property with CD. Okay, suppose if I am having any joint development agreement, as already we have discussed in the previous case, okay, so if I am having any joint development agreement with the CD, that is corporate debtor, then I am considered to be related party according to this definition. Okay, then please remember how to determine, okay, whether related party status must be determined based on the past status or present status, how you are supposed to determine. So please remember the related party status should be determined based on the present status. Possibility is there, previously you are a related party, but now you may not have any interest in the corporate debtor. Okay, so at the time of commencement of insolvency date, okay, you don't have any relation with the corporate debtor. So in such cases, okay, so you are not considered to be related party. So the present scenario we have to take into consideration. Okay, so in the case of Phoenix Arc Private Limited versus Spade Financial Services Limited, the Supreme Court held that the financial creditors who are related parties in presentee would be debarred from the COC. So if any financial creditor at present, in present means at present. So at present, whoever is interested with the corporate debtor, Okay, so whoever is interested with the management of the company, then they are debarred from the COC, because in COC the related parties are not allowed. Okay, so you cannot form the COC with the related parties. Then in another case law, One City Infrastructure Private Limited versus Haryana Telecom Limited. So in this case law, NCLAT held that the directors who had resigned 6 months prior to the filing of application. Okay, so already the director resigned before filing of application under section 7. That is section 7, anywhere financial creditor is going to make an application. Section 10, corporate creditor is going to make an application. So that means financial creditor made an application. That means the director who was there at that time, he is not aware of the fact that the financial creditor is going to file a case. Obviously he cannot expect the future. Okay, so that's why the director who had already resigned 6 months prior to the filing of an application under section 7, okay, so he is not considered to be related party. But please remember, if he is resigning, okay, with a fraudulent intention, okay, to avoid, then in such cases he is considered to be related party. So here we have to verify, okay, whether the director who resigned from the company, is he resigning because the company is going for insolvency or liquidation, resigning from the company normally. Okay, you have to verify that fact. Okay, in another case law, Royal Partners Investment Fund Limited versus Mohanlal Jain, the NCLT Mumbai bench held that the persons to be shown to be related party as on the insolvency commencement date. So please remember, in this case law, it was reiterated. Already Supreme Court in the case of Phoenix Arc Private Limited, it was held that the persons must be related party as on the date. That is, on the date, if he is related, then they are debarred from the COC. So in the case of Royal Partners Investment Fund Limited versus Mohanlal Jain, Mumbai bench NCLT reiterated that the person to be shown to be related party must be as on the insolvency commencement date, he should be related party. Then only we don't include him in the COC. Then in another case law, Kwam Ruddin Faizi versus Kaizen AAC Block Private Limited. So in this case law, Mumbai bench NCLT. So if any person resigns to escape the consequence of section 5 subsection 24, so he may not be permitted. As already I told you, if you are resigning in the normal course of business, maybe due to personal reason, then that's okay. But if you are resigning only to escape the consequence of section 22, so you wanted to sit in the COC, okay, so you know that the company is going for liquidation, okay, the company, and someone is going to file a case against the company, you know that. So in advance, you know. So after knowing that, if you are resigning from the company, then you are not permitted. Okay, so you have to see circumstantial evidences accordingly. Okay. So in another case, Bank of India versus IRIS Electro Optics Private Limited. So NCLT Hyderabad branch. If the resignation is mala fide, okay, so with mala fide intention, with guilty intention, if I am resigning, as already explained to you, okay, then such person cannot be allowed to be a member of COC. Okay, so this is about the related party status, how to determine. Then, whether key managerial personnel of CD or relative of KMP, is he eligible? No. Okay, so key managerial personnel of CD. So who is considered to be key managerial personnel? There is a definition is there under the Companies Act. Key managerial personnel includes all the board of directors, managing director, manager, whole-time director, your company secretary, CFO, CEO, or any other person. Okay, so they are all considered to be key managerial personnel within the meaning of Companies Act. Okay, so this key managerial personnel of CD, there is corporate or relative of KMP, they are not eligible. They are considered to be related party. Okay, then a LLP partnership in which a director, partner, or manager of the CD. Okay, so if any person, if any LLP is there or any partnership is there where the director, partner, okay, in which a director, partner, or manager of a CD is a partner. Okay, then in such cases, they are not eligible to act as a member in the COC. Okay, they are considered to be related parties. Then a private company or public company in which a director, partner, manager of the CD is a director and holds along with his relative more than 2%. Okay, suppose take the example, CD is having one director. Okay, then this director is or CD is having maybe director, partner, manager, whatever it is. Okay, so this person is having some relation, that is, he is having some shares in one public company or private company. Then such private company or public company cannot be the member or cannot be the member in the COC. Okay, so if they are having more than 2% of the share capital, then let us discuss whether any body corporate whose board of directors or managing director or manager in the ordinary course of business acts on the advice or directions or instructions of a director, partner or manager of the corporator. Okay, suppose they are accustomed. Okay, suppose one body corporate is there. Okay, whose board of directors, manager or manager. Okay, so that is key managerial personnel. If these key managerial personnel in the ordinary course of business, they are acting in accordance with the maybe one director, partner of corporator. Okay, so this corporator directors are giving instruction to that body corporate. That body corporate is acting in accordance with these directions. Then whether that body corporate is considered to be related party to the corporator. Okay, so it was held that yes. So in the case of Anuj Jain versus Axis Bank, Supreme Court held that the transaction must fall into place as a part of the undistinguished common flow of the business done. So what is considered to be okay in the ordinary course of business? So when I am saying that, let us understand one example. Suppose take the example, Mr. A is a director in the corporate debtor. Okay, in accordance with the directions given by Mr. A, one corporate body is there, that is body corporate is there, maybe let us imagine ABC company. Okay, so in accordance with the directions given by Mr. A, ABC company is acting. Okay, so when they are considered to be acting in accordance with the directions given by Mr. A, if, okay, so in this case, like, it was held that if this company is accustomed to act or the transaction which is done by this company, which is a part of the undistinguished common flow of the business, that is regularly what, okay, so whatever they are doing, this company is doing, this is done in accordance with the Mr. A directions only, then okay, he is considered to be related party. Okay, so it was held in the case of Anuj Jain versus Axis Bank by the Supreme Court. Okay, so in another case law, Jayanta Banerjee versus Shashi Agarwal, NCLAT. In this case law, a company in which the director of the CD was also director. Okay, suppose one company is there, corporate debtor is there. The director of this corporate debtor is also director in this company. Then whether this company will be a related party or not, yes. Okay, company in which the director of the corporate debtor was also a director, then such company would fall within the purview. That means this company is considered to be related party for the purpose of this corporate debtor. Okay, then in another case law, Telangana State Trade Promotion Corporation versus AP Gems and Jewelry Park Private Limited. Okay, in this case law, NCLAT judgment. In this case law, the nominee director of the creditor on the board of CD, okay, is considered to be related party. Suppose the financial creditor, generally this is a normal practice. As a financial creditor, whenever you are giving loan to the company to protect your interest, it is a general tendency that the financial creditor will appoint the nominee director, because as a person who is giving loan to one company, I should ensure that the company is running properly. So that's why I may appoint one nominee director. So whenever I am appointing the nominee director, this director will hold the office at the discretion of the financial creditor. Okay, now at the time when the company is taking the decision before this CRP process, even this nominee director is also there. So that's why the code is saying that the nominee director of the creditor on the board of CD, the individual who is acting as the nominee director, because he is there when the decisions was taken previously, so this person is also considered to be related party. Okay, so he is not eligible. Maybe the financial creditor can appoint some other person, but the nominee director who acted as a director in that company previously cannot be appointed as a member in the COC. He is considered to be related party. Then who else is considered? Section 534 clause H. Any person on whose advice, directions or instructions a director, partner or manager of the corporator is accustomed to act. Okay, so previously, okay, so even previous slide also we have discussed. Okay, so on the advice, then here also we are discussing on the advice. Then what is the difference between clause F and clause H? In the previous scenario, we have discussed that. Imagine corporate debtor is having one director. Okay, there is one body corporate is there. This is corporate debtor, this is body corporate. Okay, so as per the directions given by the director of this body corporate, this corporate debtor, this body corporate is acting. That means who is accustomed to act? This body corporate is accustomed to act as per the directions given by the corporate director of corporate debtor. Now we are talking about the scenario where any person on whose advice, directions or instruction a director, partner or manager of the corporate debtor is accustomed to act. Now we are talking about the scenario where someone else is there. Okay, that person is influencing the director of this corporate debtor. Okay, so any person on whose advice, directions or instruction a director, partner or manager of the corporate debtor is accustomed to act. So in the previous scenario, the corporate debtor person is influencing. Okay, in this scenario there is H, other person is influencing the director of corporate debtor. So that is the difference between clause F and clause H. Okay, so anyway, these two scenarios you are not eligible to be the member of corporate committee of the creditors. Okay, you are considered to be related party. So let us discuss few judgments. In the case of Sri Infrastructure Finance Limited versus Ashish Chacharia RP of Odisha Slurry Pipeline Infrastructure Limited. So in this case, NCLAT held that any person includes. So when they are using the word any person, because if you observe the definition, any person on whose advice. So who is considered to be any person? Any person includes individual, firm, company or any other entity. Okay, so any person, whoever is influencing the director of the corporate debtor, such other person, any person can be anyone. Okay, so any person can be individual, firm, company. So whoever is influencing the director of corporate debtor, he is considered to be related party. Okay, then in the case of Fionis R Private Limited versus Paid Financial Services Limited, so Supreme Court held that the influence may be indirect or direct. Okay, so when I am saying that according to whose instructions, directions, so that means I am having some influence. Okay, so this influence can be direct or direct, it can be indirect also. Okay, so in both the ways I can have the influence. Okay, then other scenario, a body corporate which is holding subsidiary or an associate company of the corporate debtor or a subsidiary of a holding company to which a corporate debtor is a subsidiary. Okay, so what they are saying, a body corporate which is holding subsidiary or an associate company of the corporate debtor. Okay, so that means here corporate debtor is there. For this company you are having maybe holding company, maybe subsidiary company, maybe associate company. Okay, or a subsidiary of a holding company to which corporate debtor is a subsidiary. That means they are saying that imagine this X company is there. Imagine my right hand is always corporate debtor now for the time being. Okay, so now there is a corporate debtor is there, where for this corporate debtor there is a holding company is there, or else or subsidiary company is there, or else an associate company is there. Anything is possible. Or this company who is a holding company is also having one subsidiary company, another subsidiary company is there. Okay, so these are all the people who are considered to be related party for the purpose of this corporate debtor. Okay, now let us. In the case of V Mahesh, liquidator of Nagarjuna Oil Corporation Limited versus Sai Ramesh Kanuparti, RP of Coastal Oil and Gas Infrastructure Private Limited. So Amaravati bench NCLT held that associate company includes. What is the meaning of associate companies? Associate company includes joint venture of CD. Suppose if CD is having any joint venture with another company, okay, even this joint venture is also considered to be associate, because in the normal circumstances associate company definition is given under the Companies Act. Okay, under the Companies Act, associate company means any company in which if that company is having more than 20% of the share capital in another company. Okay, suppose A company is there, B company is there. A company is having 20% of the share capital in B company, more than 20%. Obviously less than 50%. Okay, so more than 20%. If A company is having share capital in B company, then these two companies are considered to be associated companies. Okay, so here under this legislation, okay, so associate company does not mean that only having the share capital. Suppose possibility is there, A company, okay, they are having one joint venture. So they may not have any share capital. Maybe they are having some intellectual property. They are working together. In such scenario, the associate company, okay, in such scenario, that joint venture is included within the meaning of associate company, because these two companies are working together. So that's why these two companies are considered to be related party. If insolvency process is going on against this company is closely associated. So that's why this company cannot be a member of COC. Okay. Then another scenario. Clause J. any person who controls more than 20% of the voting rights in the corporate debtor on account of voting rights, ownership or voting agreement. Okay, so if any person. So here what do you mean by person? Again, you have to refer the definition of person. Okay, so person includes natural as well as artificial personality. Okay, so in the case of Sri Infrastructure Finance Limited versus Ashish Chacharia RP of Odisha Slurry Pipeline Infrastructure Limited, NCLAT held that one of the creditor indirectly controlled more than 20% of the shares and voting rights. Okay, so in this corporate debtor, one creditor is there who gave the loan. This creditor is also having 20% indirectly. Okay, so indirectly controlling more than 20% of the shares in corporate debtor. Okay, then such creditor is considered to be related party. Okay, then in another case law, Sai Peace and Prosperity Apartment Buyer Association versus ASK Investment Managers Private Limited. So in this case law, NCLAT held that a portfolio manager is there. Okay, this portfolio manager invested in the debentures of corporate debtor. Okay, then by virtue of whenever you are issuing the debentures, generally the debenture holder will have certain rights depending on the agreement between the company and the debenture holders. Okay, by virtue of the agreement between the company and the debenture holders, this portfolio manager who invested in the company, okay, so by virtue of various clauses in the agreement, he is exercising some significant influence in the corporate debtor. So now actually this portfolio manager has invested in the debenture. That means it is a debt capital. He is a creditor. But is he considered to be related party or not? Yes. Because even though he is a creditor, but he is having some influence on the corporate debtor because by virtue of clauses in the agreement. Okay, so that's why in this case, NCLAT held that, okay, he is considered to be related party. Okay, then let us discuss another scenario. Any person who control the composition of board of directors or corresponding governing body of the corporate debtor. So any person who is able to control the composition, okay, who should be appointed as a director, okay, who should retire, okay, when he should retire. So everything is decided by someone. Okay, so any person, whoever is controlling the composition of board of directors or corresponding governing body. So here in case of company, board of directors will be there. In case of other thing, maybe you can have some other scenario. Okay, so suppose body corporate is there. In India, we are calling it as a board of directors. In other country, maybe we can have some other name. Okay, so corresponding governance body. So that's why they are using the word governing body. Whatever may be the name that you are using, governing body. Okay, so then he is considered to be related party. So it was held in the case of Telangana State Trade Promotion Corporation versus AP Gems and Jewelry Parks Private Limited. So in this case, NCLAT held that where a creditor had a right to nominate two directors. Okay, so a creditor is having nominate two directors, right to appoint two nominate directors. So that means he is having control over the directors, composition of board of directors. So two directors must be appointed by him only. So that's why this creditor is called as related party. Okay. In another case, Sri Infrastructure Finance Limited, these cases generally do repeat actually. So Sri Infrastructure Finance Limited versus Ashish Chacharia RP of Odisha Slurry Pipeline Infrastructure Limited, NCLAT. In this case, NCLAT held that creditors who controlled majority of the shareholding, okay, in the CD indirectly had means to control the constitutional board of directors. So when you are controlling majority of the share capital in the corporate debtor, then obviously you are having control over the board of directors. Okay, so they are held to be related parties. Okay, within the meaning of this section. Then in another case, IDBA Trusteeship Services Limited versus Abhinav Mukherjee. In this case, NCLAT held that any person who is associated with CD on account of participation in policy making process. Okay, so suppose if someone is participating in policy making, okay, so the CD is making some policy framework. So in that policy framework, one person is participating. Then obviously, why he will participate unless he is having some influence on the board of directors? Generally, you don't allow other person. Okay, so the person who is participating in the policy framework, he is considered to be related party within the meaning of this section. Okay, that is actually clause M. Okay, section 50, section 5, subsection 24, clause M. Okay, so within the meaning of clause M, a person who is associated is also considered to be related party. Okay, Then please remember how you are going to decide whether someone is a related party or not. Okay, so whether someone is a related party or not, we are going to decide on the basis of person. It is not based on the transaction. Okay, so if that person in one transaction is related, okay, suppose if he is going out, he cannot say that I am not related, because you are the same person who is involved previously. Okay, so that's why it is not transaction centric, it is person centric. Okay, so because the persons are the persons, that is individual persons are there who are going to be influenced or who are going to influence. Okay, so that's why we are going to consider the person but not the transaction. Okay, so in the case of Phoenix Arc Private Limited versus Spade Financial Services Limited, the Supreme Court held that a financial creditor who in presentee, that is present, who in presentee is not a related party. Okay, so in previously he may be related, though he is previously a related party, but presently he is not related party. Okay, so we don't see the previous transaction. Okay, we'll see the person. Okay, so at present, is he related or not? If he is not related, then he is eligible. Okay, so it is not, but he can be a member in the COC. Okay, then according to it was commented actually in the Insolvency and Law Committee report 2020. Okay, so they were of the opinion that the disability imposed under section 21 clause 2 subsection 2 pertains to the related party financial creditor and not debt it is owned. Okay, so we are talking about the person, we are not talking about the debt. So that is where we are imposing the restriction. Okay, so that's why we can say that, okay, person is involved. If person is involved, he cannot be considered, or he is not related party. Okay, we are not going to consider the debt transaction. Okay, then in another case law, City Securities and Financial Services Private Limited versus Sudeep Bhattacharya, RP of Reliance Naval and Energy Engineering Limited. So in this case law, NCLT Ahmedabad bench held that where a related party debt is assigned for a valuable consideration to a third party, okay, then such third party can be a member of the COC. Okay, so if related party has already assigned, that means someone else purchased or someone else with a valuable consideration, someone else received, then obviously the third party is not considered to be related party. Okay, because already it is parted from the related party to the third party. Okay, who is nowhere related to the company. Okay, CD. Financial services service provider becoming related party solely on account of conversion or constitution of debt to equity, okay, remains a member of the COC. Okay, so if you observe, if any financial service provider, okay, if he is becoming a related party, so what is this, what they are saying, this is there under section 21 subsection 2 second provision, which says that, as already we have discussed, if any financial service provider is there, he has given the debt to the company and this debt is converted into equity. Okay, if this debt is converted into equity, actually when he is becoming the equity holder, he is a member of the company. So he is a related normal in the normal circumstances. But here, because he is a financial service provider, merely because his debt is converted into equity, you cannot call him as a related party. Why? Because he is not the investor who is investing actually. Okay, he is a lender. Okay, because of some other circumstances, because of the policy, the debt is converted into equity. So when you are converting the debt into equity, so you cannot equate this person with the normal members. Okay, so that's why he is not considered to be related party. Okay, so in the case of Phoenix Arc Private Limited versus Spade in Financial Services, already we have discussed. In the same case, the Supreme Court held that financial service provider whose debt is converted into equity remains a member of COC. Okay, so because he is giving the loan in the professional capacity, because it's a financial service provider. Okay, it is regulated by the regulatory authorities. Okay, so they are converting not just like that. Okay, when they are converting the debt into equity, this is as per the RBI regulations. Okay, so that's why they are still remains to be member of COC. In the case of Sai Peace and Prosperity Apartment Buyers Association versus ASK Investment Managers Private Limited, NCLAT, in this case, NCLAT held that if the transaction is not pure play, okay, suppose take the example, financial service provider is there, he is converting the debt into equity, but there is not a pure play. Okay, so there is not doing actually properly. In such cases, financial service provider cannot be the member. Okay, so he cannot be the member of COC. Okay, so it should happen as per the rules. Okay, So next, each creditor in a consortium shall be the part of COC. Please remember, okay. So who can be the member of COC? Each creditor. Okay, in a consortium, suppose 10 people, 10 financial creditors together they are investing. They are giving loan, investment, debt equity, okay, debt capital. So together they are giving. So each and every creditor shall be a part of COC. Then in another case, S-Pay Saris Private Limited versus Skipper Textiles Private Limited. So in this case, NCLT Kolkata bench held that where the financial institution is a part of the consortium, but please remember it retains its individual identity in the COC. So as already I told you, though you are a part of consortium, but each and every financial creditor in the consortium will have the voting rights according to their percentage. Okay, how much loan they gave, according to their percentage, each and every financial institution will have a stake in the committee of the creditors. Okay, they'll have their identity separately. Let us recap what we have discussed today. In today's session, we have discussed who are considered to be related parties. In the previous session, we have discussed that the related parties to the financial creditor cannot be a part of the committee of the creditors. So in this class, we have discussed who are considered to be related parties. So that is section 5, subsection 24. Then class A, class B, class C, all these classes deals with the who are considered to be related parties. So a director or a partner of a corporate debtor or a relative of such debtor or partner of the corporate debtor is considered to be related party. Then any body corporate whose board of directors, managing director or manager in the ordinary course of business acts on the advice or directions or instructions of a director or partner or manager of the corporate debtor. So these concepts we have discussed with the relevant judgments. Then any person on whose advice or directions or instructions a director or partner or manager of a corporate debtor, if they are accustomed to act in accordance with the directions of any person, then such other person is considered to be related party. Then any person who controls the composition of board of directors or corresponding governing body of the corporate debtor, then such person is considered to be related party. Then if any person is having the control over the composition, he is considered to be related party to the corporate debtor. Then the disqualifications are based on the related party is a person centric, not the transaction centric. So that means we should understand it is not it is not transaction centric, but it is at the person centric. So we have discussed what is the meaning of person centric and transaction centric in this class. Then financial service provider becoming a related party solely on account of conversion or substitution of debt to equity or remains a member of the COC. So here we have discussed that suppose if any financial service provider, if he is giving any loan, subsequent to that, if the loan is converted into equity, whether is he considered to be related party. We have discussed that merely because the debt of the financial service provider is converted into equity, he will not be considered to be related party for the purpose of this class. So today in this lesson we have discussed who are all considered to be related party so that we can understand who cannot be a member in the committee of the creditors. Thank you.